Good afternoon. My name is Renee Townsend, and I'm a partner at Secrest Wardle. Today's presentation is on the premises liability topic of special considerations for landlords. This topic will include a review of the common law and statutory duties imposed on landlords, the various claims that can be made against landlords, and the defenses available to those claims. I presume that everyone who's attending this presentation is either an attorney, an insurance adjuster, or someone who wandered into the wrong room and is now feeling too awkward to leave. Too bad for you, as we've begun and you certainly cannot leave now. That being said, this presentation presumes some basic understanding of premises liability, though I will briefly discuss those basics. Without any further delay, let's get started. We begin our journey with common law duties. The duty a landowner or possessor has depends on the legal status of the individual on the premises. There are three legal statuses recognized in Michigan, and we will begin with the simplest one: trespassers. There is generally no duty owed by a landlord to a trespasser. We will discuss the very limited duties later. The next level of legal statuses is licensees. A landowner owes a licensee a duty to use ordinary care to prevent injury arising from the landlord's active negligence. We will discuss what that means shortly. Finally, the highest level of duty owed to an individual on a landowner's property is to invitees. A landowner owes an invitee a duty to use ordinary care to keep the premises in a reasonably safe condition. But what does this all mean? Let's examine each of those duties a little more closely. What is a trespasser? A trespasser is a person who goes upon the premises of another without their express or implied permission for his own purposes and not in the performance of any duty. Under most circumstances, landowners have no duty to keep their premises safe for trespassers. That means there's no duty to warn of any dangers, even if they are known to the landowner and could not be known to the trespasser, and no duty to make the premises safe. There is a duty, however, not to actively harm the trespasser. So a landowner can say, "You're on your own, trespasser, you came onto my land." What a landowner cannot say is, "I have rigged this shotgun to be triggered by a tripwire. If you come onto my land, trespasser, I am a loon." So a landowner cannot set traps for trespassers. What is a licensee? A licensee is a person who is privileged to enter the land of another by virtue of the possessor's consent. A landlord's duty here is to use ordinary care to prevent injury arising from the landlord's active negligence. A landowner is liable to a licensee for a condition on the land only if the possessor knew or should have known of the condition, should have realized that it involved an unreasonable risk of harm to a licensee, and should have expected that the licensee would not discover or realize the danger. The possessor has breached that duty when he has failed to exercise reasonable care to make the condition safe or to warn the licensee of the condition and the risk, and where the licensee did not know or have reason to know of the condition and the risk involved. However, there is no duty to inspect or warn except for concealed or hidden dangers of which the possessor actually knows. You should note that when children are involved, a special rule imposing a higher degree of care may apply. I call this the dumb kids rule, though that is not the official name. What the dumb kids rule basically says is that a landowner is required to take into consideration that a child's ability to appreciate the full extent of the risk is different from that of an adult. What is an invitee? An invitee is a person is determined to be an invitee when his visit can reasonably said to confer a business, commercial, monetary, or other tangible benefit to the entity. Landlords have the highest duty to invitees. Landlords are required to maintain the premises, inspect the premises for any hazards, and warn an invitee of any hazards. Generally, a landlord is required to exercise ordinary care and prudence to keep the premises in a reasonably safe condition. So those are the basics of what you need to know about the duties owed by a landowner to a person who comes onto their land. But the term landowner in itself is kind of misleading because a landowner is not the only person who may be liable in a premises liability case. The real issue is possession and control of the subject property. Normally, the only proper defendant in a premises liability case is the entity that had possession and control over the property. So ownership of the property is not dispositive. Legal title to the property is not dispositive. Instead, liability depends on the actual possession and exercise of control over the property. Now I'm going to drop a knowledge bomb on you. See that little icon there? That's a knowledge bomb. For a landlord, ownership of the land keeps the landlord liable. Ownership of the land keeps you liable even if you have relinquished possession and control to another party, such as a management company. However, the entity currently in possession and control of the property also has duties to the plaintiff, so that management company can be sued right along with the landlord. Now that we have addressed the common law duties of property owners in general, and landlords specifically, we can discuss the specific statutory duties imposed on landlords in Michigan. The Landlord-Tenant Act can be found at MCL 554.139 and the subsequent statutes. The plain language of MCL 554.139 states that a landlord has a duty to keep the premises and all common areas fit for the use intended by the parties, and to keep the premises in reasonable repair during the term of the lease, and to comply with the applicable health and safety laws of the state and the local unit of government where the premises are located. Now, it says premises and all common areas. So what are common areas? Common areas are areas located within the parameters of an apartment complex, accessible to all tenants, and maintained by the landlord or his employees. So that includes sidewalks, parking lots, grassy knolls, playgrounds, areas of that nature. It does not include the area inside of an apartment. It should be noted that the parties to the lease may modify the obligations imposed by this section of the Michigan statutes where the lease has a current term of at least 1 year. The statute also specifically states that it should be liberally construed, and that giving the tenant or lessee an opportunity to inspect the premises before entering into an agreement does not absolve the landlord from these statutory duties. Now, most of you are probably aware of a doctrine called the open and obvious defense, except for maybe that guy who wandered in and was too uncomfortable to leave. We haven't forgotten about you. For that guy's benefit, I'll explain it. The open and obvious defense essentially states that a landowner is not liable to an invitee for a condition on the land that is open and obvious. It's pretty straightforward in its definition. However, the open and obvious defense cannot be used to avoid a specific statutory duty. In the case of a landlord, the open and obvious defense does not apply to cases where plaintiffs are claiming breach of a statutory duty, such as those imposed in the Landlord-Tenant Act. So for instance, the open and obvious defense does not apply to a landlord's duty to keep its premises in reasonable repair, keep the premises fit for its intended use, or follow local ordinances. However, if plaintiffs fail to prove a breach of a statutory duty, the open and obvious defense does apply. I want to quickly make a couple of specific points relative to the statutory duties of landlords and the open and obvious doctrine. The Michigan Supreme Court has held that the duties imposed by the Landlord-Tenant Act exist only between the contracting parties, being the landlord and the tenant. Therefore, the statutory duties do not apply to social guests of the lessee. The open and obvious defense will apply to claims by social guests. What this means is that a social guest cannot claim, for instance, that the landlord failed to keep the subject premises in reasonable repair to avoid the open and obvious defense. The question may arise of whether a landlord owes those statutory duties that we discussed above as related to a fixture on the property. What are fixtures? The term fixtures generally means any personal property that is affixed to the real property. This is hard to define, but perhaps the clearest answer was offered by Professor Steve Nippenberg of the University of Oklahoma College of Law. He said, quote, "You take the world, you shake it, and everything that doesn't fall off is a fixture. My personal favorite answer is to paraphrase U.S. Supreme Court Justice Potter Stewart in an old case in which he compared something else, not a fixture, but stated this: a fixture is like pornography. It's hard to define, but you know it when you see it. Some samples of possible fixtures include anything from furnaces, sinks, countertops, solar panels, wind turbines, things like that. A landlord generally does not always owe those statutory duties in the Landlord-Tenant Act relative to claims involving fixtures. For example, one case held that where a pilot light went out on a furnace and the landlord instructed the tenant to relight it himself, the landlord was not liable for statutory claims made under the Landlord-Tenant Act when that pilot light blew up and caused some injuries to the plaintiff. Finally, I want to discuss the issue of notice. Where a landlord does not have notice of an allegedly defective condition, Michigan courts have held that the Landlord-Tenant Act does not apply. For example, in one case, a plaintiff attempted to close a sliding glass door, but it would not close properly. The plaintiff pushed on the door with both hands in an attempt to close it completely. In doing so, her right hand slipped and went through the glass pane in the door, and she sustained serious injuries. The plaintiff asserted a breach of the statutory duties under the Landlord-Tenant Act. The court held that, because the landlord was not on notice of the allegedly defective condition, being the defective door, neither statute applied. This same principle applies most frequently in Michigan in snow and ice cases. In case you're unaware, Michigan winters sometimes produce snow and ice. And sometimes Michigan winters dump ungodly amounts of snow and ice on Michigan residents who question why they have chosen to live their life on this earth in a state that is a frozen tundra for 9 months out of the year. That aside, the Michigan Court of Appeals has repeatedly held that a landlord must have had actual or constructive notice of the existence of the alleged ice or snowy condition to trigger a duty to diminish the hazard. Absent some evidence that the icy condition had existed for any length of time sufficient that the landlord should have known about it or that the landlord actually knew about it, there is no basis for liability against the landlord. However, notice is not the only hurdle that plaintiffs must overcome in a snow and ice case. Snow and ice has been held to have been open and obvious when there are indicia of a potentially hazardous condition. For instance, if it was snowing at the time of the fall, if the temperature was below freezing, or if there were other winter weather conditions occurring at the time. Any Michigan resident should expect and know that it's going to be slippery in those conditions. However, Michigan courts have held that a landowner can still be liable for an open and obvious condition on the land where that condition has some special aspect. A special aspect can be a condition which created an unreasonable risk of harm to the plaintiff or a condition that was effectively unavoidable by the plaintiff. The touchstone of the special aspects analysis is that the condition must be characterized by its unreasonable risk of harm. Thus, an unreasonably dangerous hazard must be just that, not just a dangerous hazard, but one that is unreasonably so, and it must be more than theoretically or retrospectively dangerous. Similarly, an effectively unavoidable condition must be an inherently dangerous hazard that a person is inescapably required to confront under the circumstances. However, it is not a landlord's duty to guarantee that ice never forms anywhere on its property. As long as a landlord provides a reasonable means of ingress and egress, meaning to clear your walkways or sidewalks, you've met your duty under the common law. If Grandma Josephine wants to walk on unsalted and unplowed snowbanks, she does so at her own risk. All premises owners in Michigan have these same duties and protections with regard to snow and ice. However, landlords in particular have additional statutory duties under the Landlord-Tenant Act. As we discussed earlier, a landlord has a duty to keep the premises in reasonable repair and fit for its intended use and purpose. However, there are certain rules to keep in mind when it comes to snow and ice. These stem from both statutory duties and the application of those duties to the common law. The Michigan Supreme Court has held that parking lots and sidewalks in leased residential areas are common areas under the statute listed on the slide. The natural accumulation of snow and ice is subject to the lessor's duty under the statute, but a plaintiff must show that the area was not fit for the intended use under that statute, which provides that the lessor has a duty to keep the common areas fit for the intended use, fit for the use intended. The landlord's duty in this regard concerning the accumulation of snow and ice is to keep the entrance to and the exit from the lot clear, to make sure that the vehicles can access parking spaces and that tenants have reasonable access to their parked vehicles. There have been cases in which a tenant has alleged to have slipped and fallen on ice in a parking lot, only to have that case dismissed because evidence was presented that other people were able to walk through the parking lot without falling. The courts have held that to be evidence that the parking lot was fit for its intended use. But the natural accumulation of snow and ice is not subject to the lessor's duty established in Part B of that statute, which concerns damage to the property and the landlord's requirement to repair the damage. The accumulation of snow and ice does not constitute a defect in the property, and therefore the lessor would have no duty under MCL 554.1391B with regard to snow and ice, except to the extent that such snow and ice cause damage to the property. A final note on snow and ice. If you are a landlord who is renting out a standalone house, you can draft a lease that puts the responsibility for snow and ice and other maintenance onto the renter. This eliminates the statutory and common law duties of snow and ice maintenance that would normally be imposed on the landlord. That becomes the tenant's problem. Well, it's finally beautiful in Michigan, so I don't want to talk about snow anymore. With Michigan summers, the snow goes away, the maple trees come alive, the lakes warm up, and the spiders come out. So the question is, what duty does a landlord have with regard to bug infestations? And the answer is none, really. Unless the plaintiff can prove there was damage to the premises that was caused by the spiders or contributed to the presence of the spiders, it cannot be established that the landlord failed to keep the premises reasonably repaired as required by MCL 554 Part 1B. Sorry, 169 Part 1B. A big issue recently in Michigan has been bed bugs, as it has been throughout the country. But these cases follow the same line of reason. Unless the plaintiff can prove that the landlord did anything that would have contributed to the bed bug's presence, liability cannot be established. Another issue that comes up a lot is dogs, and pit bulls in particular. Michigan courts have rejected the argument that property owners should be strictly liable for attacks by their tenants' dogs. Unlike dog owners, who are strictly liable for injuries inflicted by their dogs under the dog bite statute, more is required to impose liability on a landlord. A landlord is liable for injuries caused by the attack of a tenant's dog only where the landlord has actual knowledge of the dangerous propensities of the dog and where the landlord, having that knowledge, nevertheless leased the premises to the dog's owner or by the terms of the lease had the power to control the harboring of a dog by the tenant and neglected to exercise that power. In short, such cases often turn upon whether the landlord knew that the dog had exhibited dangerous propensities before the incident. With pit bulls in particular, it has been argued that a landlord should be held to have known about a pit bull's dangerous propensities just by the supposed violent nature of the dog breed. However you feel about pit bulls, the point remains the same. The landlord must have known about the particular dog's dangerous propensities and not just about the danger of a breed in general. Even where a lease agreement sets forth rules and regulations about keeping pets in a rented property, the landlord has no duty unless he knows about the dangerous propensities of the dog. Though spiders and pit bulls might be scary to some, the issue of criminal activity is another concern for landlords. Michigan courts have held that a landlord owes a duty both to tenants and their guests to take reasonable measures in response to an ongoing crime that takes place on the premises. This generally means calling the police. Landlords are not expected to fight crime themselves. The Supreme Court has also held that landlords have no duty to respond to criminal activity within rental units. A landlord's duty arises only when the triggering conduct occurs in the areas under the landlord's control. A final couple of quick notes before we wrap up. MCL 554.633, commonly known as the Truth in Renting Act, states that, quote, a rental agreement shall not include a provision that does one or more of the following. waives or alters a remedy available to the parties when the premises are in a condition that violates the covenants of fitness and habitability required pursuant to MCL 554.139, and exculpates the lessor from liability for the lessor's failure to perform or negligent performance of a duty imposed by law. As such, exculpatory clauses in residential leases have been held to be void as against public policy. Finally, of the things we've discussed today, all of the things we've discussed today deal with residential leases. A quick note on commercial leases. A commercial lease is treated as any other contract, so unlike residential leases, you can have all of the good stuff. Commercial leases may include provisions for a release, indemnity, exculpatory clauses, switching responsibility to the tenants, switching possession and control to the tenants, making tenants identify you as an additional insured, shortening the statute of limitations, and any other provisions which may be particular to your property. So we have reached the end of the presentation, so someone should probably wake up that guy who wandered in here by mistake. I hope that this information has been helpful to you and gives you a better understanding of the duties, obligations, and protections afforded to landlords under the Landlord-Tenant Act and the common law in Michigan. If you have any questions, please do not hesitate to contact me. My contact information is now on the screen. Or you can look me up on our website, www.secrestwardle.com, or on LinkedIn by my name, Renee Townsend. I hope you enjoy the rest of your day. Thanks for stopping by the presentation.